It's a great pleasure to join you this afternoon, and I want to thank everybody for calling in on this very important Zoom call about the future of the European Works Council directive. In this webinar, we are going to discuss for about 20 minutes my presentation on the reform of the EWC directive. We would like to make sure that this is as interactive as possible. So after about 20 minutes, I'm going to stop speaking, and hopefully we are going to have a discussion with some questions and answers. I see already there's many of you in the chat, and that is most welcome indeed. And I look forward very, very much to the discussion. So I'm Paul Dillon, Senior Consultant with Syndex, and I have been working for 4 years with Syndex. And what we are really going to look at today, and this is an important point, is not just the text of the directive, but also what it means for your EWC. I'm going to try and speak as slowly and as clearly as possible. And as I said, I look forward very much to the discussion. If I can begin by saying that the idea of the reform and directive refers to both the establishment and operation of European Works Councils and the effective enforcement of the rights of European Works Councils. So why are we here? What is the problem? The problem is best probably diagnosed by a major Commission report in 2018, where they looked at the entirety of the implementation of the 2009 recast directive. The original directive, of course, was from 1994, so it's now more than 30 years old. The directive was recast in 2009, and in 2018, the Commission identified shortcomings, gaps, and challenges in how that directive was implemented. What do they mean by that? Firstly, weak transnational consultation. EWCs often not receiving timely or adequate information, especially during restructuring. So that was a weakness that the Commission identified. The Commission identified practical shortcomings, gaps in how information flows between European, national and local worker representation. And that is despite the reforms of 2009, which were designed to show which were designed to better link the European and the local information and consultation. The directive, the Commission showed that despite the 2009 directive, many EWC's representatives lack the training needed to fulfill their role. The Commission found limited coverage, that despite the directive, despite the recast directive, despite the 94 directive, EWCs exist in only about 1/3 of undertakings that qualify. So if you take it, there's about 4,000 companies in Europe that qualify. Only 1/3 of them have the EWC in place. The Commission identified legal uncertainty, ambiguities in definitions, transnationality consultation rights, and this led to an uneven application and disputes. And finally, enforcement gaps, that national sanctions are often too weak or too inconsistent to guarantee compliance. So a question for colleagues on the call, looking at what we've seen there, what do you think are the key problems facing EWCs? And what I'm going to do in my next slide is I'm going to show what we in Syndex believe are the most important changes in the new directive. Okay, I hope I'm speaking slowly enough and clearly enough. What are the most important changes in the new directive? Firstly, the new subsidiary requirements, which should be seen as a base below which nobody can fall, give you 2 meetings per year. Previously, it was 1 meeting per year. The second issue is that meetings are clarified as being face-to-face. That means your annual meeting or your select committee meeting, that there should not be any imposition of meetings not being face-to-face. The third issue, which is important, is the boosting of resources, the clarification of training rights, and the boosting of rights to experts. Better access to justice, i.e. clarifying how precisely you should take a case if you need to, and stronger sanctions for companies who breach the law. A very important point that I want to make at this stage is that this meeting is an information meeting and a discussion, I hope. Information and discussion rather than information and consultation. But it's very important to consult your trade union coordinator or your trade union federation in terms of how you achieve the implementation of your rights. So I would encourage you to think carefully. So far, what have we seen? The new directive is going to bring 2 meetings per year in the subsidiary requirements. Meetings should be face-to-face, a boosting of resources, better access to justice, stronger sanctions for companies who breach the law. And that is what we in Syndex think are the most important issues. And again, to clarify, you should always remember to consult your trade union coordinator. Syndex work as technical experts, but there's a very important point, which is to consult with your trade union coordinator or your trade union federation as is necessary. So, transnationality. And in a sense, transnationality is why we're here. And transnationality can be a difficult topic to understand. I see there's plenty coming in on the chat, and I welcome that, so make sure to put in your questions for discussion. Transnationality, in the old directive, it said the transnationality would have to hit at least 2 countries in order for a decision to be transnational. Straightforward. Or if it affected the group as a whole. That point is less straightforward and has required some clarification. So there is an uncertainty. And in the new text, in the reformed text, it said there is uncertainty regarding the concept of transnational matters. So to provide clarity, it is clarified that the directive applies not only when management decisions affect workers in several countries directly, but also when a decision initially concerns only one country, yet has foreseeable consequences for workers in another country. It's a complicated concept to imagine, so let's look at it practically. The examples that are given in the text include layoffs, redundancies, outsourcing, or reallocating production. An assessment depends on both the scope of effects on the workforce and the management level at which decisions are taken. In such cases, the EWC has the right to be informed and consulted. Let's do a quick comparison. In the old directive, a matter is transnational if it directly affects workers in 2 or more member states, or if it affects the group as a whole. The last directive was the original directive was quite clear in the direct cross-border impact, i.e. moving jobs from one country to another. But many EWCs struggled with management to define what precisely it was when it came to transnationality. So sometimes there was an argument about EWC at EWC level about consultation. In the new rule, a matter is transnational, potentially if it affects workers in more than one member state, either directly or indirectly. So it is necessary now to focus on the indirect effects, the knock-on effects, and then, therefore, the potential for the EWC to be consulted is broadened. So it is necessary to look, if a decision is taken at transnational level, which directly affects one country, but indirectly affects another, it is potentially a matter for transnational information and consultation. And it is very important that EWCs are proactive, that they are actively taking up that cause, and that they are ensuring that they use that new definition of transnationality. It is all a question of timing. Information and consultation needs to be conducted in a meaningful and timely way that enables worker representatives to express their opinion prior to the adoption of the decision. Prior to the adoption of the decision, not after. And opinions issued by EWCs or employees reps must receive a reasoned response from central management or a more appropriate level of management before the decision on the proposed measure is adopted. So to recap, your opinion on a transnational matter should happen before a decision is adopted. And also, the response to that, a reasoned response, should be received before a decision is adopted. The directive clarifies that EWCs and employee representatives must be given adequate time to form, coordinate, and express their views on complex transnational matters without rigid deadlines. Consultation should occur within a reasonable time, taking into account urgency, complexity, and importance of the issue, as well as management's needs for timely decisions. This ensures both consultation and flexibility, allowing expedited procedures when situations arise. The important part to remember is that when it comes to consultation, the potential to be a transnational issue is broadened to look at the indirect effects, okay? And also, your consultation, your information and consultation should occur before a decision is adopted, and you should receive a reasoned response before your decision is adopted. A quick look again at the question of timing. The old directive, consultation was an exchange of views and establishment of dialogue, but the timing was vague, and there was no explicit obligation for management to reply to opinions. And indeed, many EWCs were not putting themselves in a position to actually create and provide an opinion. The clarification is that it should be more meaningful. Management must wait for reps' view before a decision is adopted and give a reasoned reply. And in my 4 years in Syndex, what I've seen is that to produce an opinion that can be taken into account, that is your aim and that is your goal. But doing that requires the coordination of EWC reps, not just with each other, but also with the trade union coordinator and experts. So reps have adequate time, but deadlines should be flexible. And management must respond to opinions before a decision is adopted. So again, a question for the chat is, at the moment, is your EWC operating in such a way that allows information and consultation to happen before a decision is adopted and for an opinion to be given before a decision is adopted with a reasoned response? A key part of the new directive is that existing sanctions for companies who breach the terms of the directive are too weak. So the 2018 report found that sanctions are too weak. It found that financial penalties are required for breaches of EWC obligations. So in the new directive, member states must ensure that sanctions are effective, dissuasive, and proportionate. And also, it clarifies the rights of EWCs to legal support. SNBs and EWCs and their members must have means to cover legal and participation costs. There is some limits suggested in the directive in terms of what that means, but your rights to legal support are strengthened by the new directive, and the sanctions regime is strengthened. And remember and this is a very important point to make, that under the means required, you have the right, of course, to experts, and now explicitly the right to legal experts. And of course, the costs are to be borne by central management if reasonable. So remember, this is very important. 3 very important points to remember. Member states shall provide for appropriate measures in the event of failure to comply with the national provisions adopted in this directive. So what does that mean? And I'm sitting, of course, in Dublin, Ireland. It means that the Irish government is obliged to ensure that the sanctions that are in place in the Irish legislation for EWCs who are headquartered here must be adequate, must be dissuasive, and must be proportionate. So they shall ensure, that's the member states, that adequate procedures are available to enable the rights and obligations deriving from this directive to be enforced in a timely and effective manner. Penalties must be introduced that are effective, dissuasive, and proportionate. And that is important in the context of infringements of the rights and obligations deriving from the directive. And very clearly in the new directive, member states shall provide that the reasonable costs of legal representation and participation in such proceedings are borne by the central management, or take other equivalent measures to avoid any de facto restriction of such access for reasons of lack of financial resources. I hope I'm clear so far. And again, I warmly encourage any questions or comments into the chat. I know they're being monitored carefully by Syndex, not moderated, monitored, and I look forward very much to the discussion. So what are we talking about when we talk about justice? We're talking about clearer access to justice. We're talking about stronger penalties when management breaches the rights of EWCs, and we're talking about strengthened access to legal support through the EWC. A very important point in relation to the EWCs and in relation to EWC members is the resources that they can use. In Syndex, we often use the slogan, putting you on an equal footing with management. It is absolutely crystal clear in the existing directive that you have rights to experts and that should be covered under the means required, both EWCs and select committees. So EWCs may be assisted by experts of their choice, union coordinators, legal or technical experts. An important point that is of interest, I know, to some people on the call today is that the new directive makes it crystal clear that experts can participate in meetings with management. Now, that is often the case at the present time, but that is clarified in the new directive. It does say, and I mean, we only have a short period of time, so it's important to clarify that costs must be notified and estimated to central management. So there is a cap put on potentially the capacity of reps to act. But what I would say, and I know we will discuss it at the end, a lot of this will come down to your EWC and your trade union coordinator and your trade union federation to work together to ensure that you get your rights to the resources that you need. So EWC agreements will have to define the resources, fees, and participation of experts. And an important point that I thought I would put in quite early is that the law clarifies that the appointment of employee reps is governed by national law and practice, but trade union employee representatives, and that can be defined in the law as trade union representatives, if the national law allows, can sit on an EWC. At the moment, if the national law allows, an employee representative who doesn't work for a company can sit on an SNB, but in the new directive, that is broadened to include employee representatives potentially sitting on EWCs if the national law allows. An important discussion relates to the question of should EWC meetings be in person or hybrid. It is An important discussion in the context of achieving your rights to information and consultation. The directive states, the old directive from 2009 states, it requires that the venue of meetings is to be agreed. The clarification in the new one is that agreement should specify the format of meetings, in person, online, or hybrid. It avoids doubt. It confirms that parties can agree virtual or hybrid formats. But to be crystal clear, that is by agreement. The new directive does mention what they describe as environmental benefits and efficiency, etc. But it also mentions the balance, that physical meetings remain important for trust, confidentiality, and personal exchanges. And quite frankly, colleagues, it can be very, very difficult to conduct an information and consultation meeting online. And it's very important to clarify that those formats are by agreement only. Hybrid is the exception, not the rule, and face-to-face includes select committees. An important point to make is that the new directive effectively deletes the exemption for pre-96 agreements. Now, most people on the call will either be members of EWCs who have an agreement or trade unionists who work with EWCs to have agreements. And I know that there's some academics and others who have an interest. So most are dealing with EWC agreements. But there are EWC agreements from before 1996, which were exempt from the first directive and the second directive. And those bodies operate outside union laws. And for legal clarity, equal treatment and effectiveness, this exemption is now deleted. So employees and all community undertakings should be able to request an EWC. Existing agreements remain valid under national law, but new negotiations must follow the directive, and subsidiary requirements apply after 2 years, reduced from 3. So I'm not sure if it affects many people on the call, but the important point is that the agreements from before 1996, the right to change them is strengthened in terms of the subsidiary requirements kicking in after 2 rather than 3 years, and they are no longer exempt from the European law which governs European Works Councils. A few other important points which I would like to make at this point. And again, I'm very conscious of time, and people who know me from the call know that I tend to speak a lot, but I won't speak beyond another 5 or 10 minutes max. I give you that commitment in order for us to facilitate the discussion. The annual meetings in the subsidiary requirements are to be held in person. That's 2 meetings per year in person. It's an important point to clarify because that gives you a second meeting per year. If you currently have 1, you've got the capacity to move to 2, and that's an important point to make. For those reps on the call who are involved in the special negotiating body, or the SNB, the SNB is what preempts the European Works Council. Central management is required to convene a number of meetings within SNB sufficient for both parties to reach an agreement. At the moment, the directive states that there should only be, it only states meeting. Now, in actual fact, there'll often be many meetings over the current 3-year period, but it only gives you the right to 1 meeting. It should be specified that the subsidiary requirements laid down by the directive apply when a first meeting of the special negotiating body is not convened within 6 months following a request to establish an EWC, irrespective of whether central management expressly refuses to commence negotiation. In order to avoid disputes, it should be specified that the central management should be required to cover the reasonable cost of training and related expenses to the members of the SNB and the EWC, where it is necessary for the exercise of their duties where management has been informed of those costs in advance. This is not a huge change. It just clarifies and reinforces the rights of SNB members. What are SNB members entitled to? Training, and they're entitled to expert trade union support in the conduct of the negotiations and in the interactions with management. So moving on to confidentiality. I know it's a popular topic, and a difficult topic oftentimes. So what I've done is 2 slides, which I hope are simple and straightforward. Management may share information in confidence with EWCs, SMBs, or reps. Confidentiality only in the legitimate interest of the undertaking. The national law is to define objective criteria for legitimate interest. And if I can say to the colleagues on the call, an important part of all of this is obviously today we are discussing the directive, the reform, but the directive must be transposed into legislation. So there's a lot of work to be done in terms of preparing the ground for that implementation. So the national law is to define what the legitimate interest of the undertaking is. Management must provide a justification when imposing confidentiality. Confidentiality applies only as long as the reasons for confidentiality persist. At the moment, the confidentiality can actually exist forever, even after you leave a company. The refusal to transmit information only if it would seriously harm an undertaking's functioning. Management must specify the reasons for non-transmission. Enough detail for legal scrutiny without revealing protected information. And a quick comparison. In the old directive, management could clarify information as confidential if disclosure would seriously harm the undertaking. Confidentiality obligation covered EWC and S&B members and any experts assisting them. No obligation for management in the old directive to explain reasons or specify duration. And confidentiality could apply indefinitely, and no explicit mention of secure storage or transmission. In the new directive, member states must define objective criteria for confidentiality. Coverage continues for EWC members and experts, so there's no great change in terms of who's covered by confidentiality, but with stronger safeguards. Management must justify the reasons and, where possible, specify duration. And confidentiality ends once reasons no longer apply. And central management may establish secure storage and transmission arrangements. So to make a summary of confidentiality and what it means, it is very important to watch what happens in terms of the national transposition, i.e. the moving of the directive into national law, because that is going to tell us a lot. It is very important to look at the, I suppose you could say, clarification of your rights to confidentiality. If we go back to there's been plenty of reports done back down through the years that confidentiality is an issue for EWC members. So this directive changes that in the sense that it offers some safeguards in terms of legitimate interests, in terms of timelines and so on, but a lot will depend on the national transposition, and a lot will depend on how EWC members use confidentiality. And I would again strongly encourage reps to look very carefully at confidentiality in agreements and work with their trade union coordinator on them. There has been some discussion about gender and EWCs. I suppose it's a fact that EWCs do not have a gender balance. I suppose it's a fact that that is not something new. So we've had this for some time. The history of the EWCs are that they are predominantly dominated by men in terms of membership. I would say it's about 85%. That's what some of the figures are showing us. In the new directive, it's saying at least 40% men or at least 40% women. If balance is not reached in terms of membership, the SNB must explain the reasons in writing to the entire workforce. But lack of gender balance does not prevent the creation of the body. There was a reform in the last directive also pushing towards improving the gender balance. And quite frankly, if I'm honest, I don't think that it made a huge amount of difference. This time around, there's a target introduced, 40%. But the important point to remember is that it is up to national law to send the members to an SNB or an EWC. So let's watch that space and let's see what happens. And perhaps we will have it will be one of the elements for discussion. I'm going to move towards conclusion, and apologies if I have taken more time than I intended to do. I only have 2 more slides to go. So what is the countdown? I suppose the first thing to say, to be frank about it, I'm just being honest and showing my own hand. I quite frankly, perhaps naively, expected to be speaking to you with the directive already passed through the European Parliament. And I know there's colleagues on the call who are perhaps more familiar with this than me, people perhaps involved in trade union federations or perhaps closer to the law-making mechanisms in Brussels. We expect, as far as I can see, for a vote to be held in November on the passing of the directive. Okay, that's what we expect. Don't hold me to it, colleagues, and perhaps others on the call have more knowledge. As I said, I was the person who expected this to have already happened. Once it passes through the final hurdle, there's 2 years for the transposition into national law. Each EU country has 2 years to write the new rules into its national law. So that means by late 2027, the national laws will be ready and companies can see what they must follow and reps see what they must follow. Let's take the November 25 deadline, expected. The directive is passed. The directive becomes law 20 days after it is published in the EU's official journal. This is the official starting point, okay? So that is the date when the new directive becomes law, and then we see what happens after that. From November 2028, there is the application of the national rules. 3 years after transposition, the new rules start to apply in real life. This is the date when companies must follow them. So you get 2 years for transposition, and then you get a period of a year where there is this, I suppose, there is a waiting period before things must happen. So, colleagues, this should be seen as the beginning rather than the end. We have some time. That's presuming that it passes through in November. So I hope that has been clear, that part, because I know there is sometimes questions and there are some complications. So we expect a vote in November, all going well. As I said, other colleagues in the chat may have different views, different opinions, more knowledge. But that is when we expect it. And then after that, there is a 2-year period for transposition and another 1 year for it to become law. If you already have an EWC agreement, after the national laws are published, an EWC or at least 100 employees across 2 member states can request that the agreement be renegotiated to meet the new requirements. So it is a situation where you will be looking to meet the change in your agreement. Companies and employee representatives have until the application date, 2 years, to adopt their agreements. If the agreement is not updated by that date, the company must follow the new rules anyway, because the national law will now apply. So companies with an existing EWC have the chance to bring their agreements into line with the new rules before the laws become mandatory. So it is difficult because I know colleagues will say, when do we need to do this and how do we need to do this? The time is now to start looking at the difference in your agreement and the directive, whether it be the meetings, whether it be confidentiality or any other clause. If you have no EWC yet, the normal process remains. 100 employees across 2 member states, 150 must be at least 1 country. And if management does not convene the first meeting within 6 months, the default rules, subsidiary requirements automatically apply. On that note, and apologies if I spoke for too long, let's go to the questions and the discussion. And thank you very, very much for your attention. Thank you so much. Okay. Will I start taking the questions, colleagues? I'm joined by Shreya and Anne, and also by many syndics on the colleagues on the call. I know Stefan is on the call, Robert is on the call. We have, of course, our colleagues in Paris as well, and others. I won't mention everybody. It's a lot of people to mention. Now, the first question is, will you be sharing the presentation? Absolutely, no problem. We will be sharing the presentation. That is a guarantee. The second question, and I take it under the new directive, will exceptional circumstances meetings also be face-to-face unless otherwise agreed? Thank you very much, Stuart, for the question, and good to see you on the call. Stuart, the short answer to the question is that it is a requirement that the format is agreed, okay? The format is agreed. So the format can be hybrid, online, or face-to-face, but it's up to you to agree. So if you don't agree, then it should be face-to-face. Okay. Another question, Stuart. Does the new directive give a definition of worker, i.e. workers who are not employees in scope? Very good question, Stuart. That's a really, really excellent question. I only regret that we don't have more time to discuss all of this. So the question is, who's covered? It's important to specify when you're negotiating your agreement to try to ensure that, if possible, you broaden out to include agency staff, subcontractors, etc. Quite frankly, Stuart, and you asked a direct question, so you deserve a direct answer, employees is still understood as direct employees of a company. Dimitri, the question of timing. Not all... a question of timing. I'm just struggling slightly to see the question. Without any real consultation, timing is everything, Dimitri. I won't use your... I'm just trying to think of a specific example. But timing is everything. How do you get effective consultation at an EWC? The first thing is there's the information and consultation are separate, and the submission of the opinion is the end of the consultation, okay? And if you don't get sufficient information and consultation, you can't produce an opinion, and therefore you can't end the process. Many EWCs have difficulties even starting the process. Some, quite frankly, don't ask. It is essential that you separate the processes out, that you get your information, that you get your consultation, and you get your opinion. And frankly, if you are not getting your information and consultation, it's important to look at your, talk to your trade union coordinator, talk to your trade union federation, and under the new law, you can access better legal support. So you should be able to look at that if you need to. So the important point is timing is everything. Try and get in as early as you possibly can, and try and ensure that if you're not getting your rights, that you trigger them. How does an EWC or EWC member pursue sanctions if consultation does not happen before a change is implemented? Does such a failure to consult have to happen consistently, or can a once-off breach be sanctioned? Brilliant question. And again, I know there's colleagues on the call who have actually more expertise and more practical support than me on this. The straightforward answer is, if you see, I'm just going to take a minute to walk back for a moment. If you see what you think is a transnational issue, but the company or management says that's not a transnational issue, it is necessary, it is absolutely necessary to try to work with your trade union coordinator, your experts, your management, to clarify what is a transnational matter. If you believe that it's a transnational matter and they are resisting, you can trigger your legal rights. And for example, we're sitting in Dublin, Ireland. Those rights are to be clarified in the new directive. The member states are to be required to tell the Commission how EWC members can access justice, okay? So it doesn't have to be repeated. It can be a once-off. Speaking frankly, the current sanctions, for example, in a country like Ireland, will have to be changed according to the directive, because it says they must be dissuasive and proportionate. So what that means will come down to the transposition of the directive into the legislation. Okay. Do we need a special negotiating body constituted for a renegotiation, or can we use the select committee for this? Well, the answer to that is it depends. And again, can I give a I don't want to give, there's quite a lot of questions and comments, I think, so I'm conscious of not going into things in too much detail. If you have an existing agreement, these standards must apply and they must be met within the time frame specified, okay? If they are not, you're going to revert to the subsidiary requirements. So, and then that would be a special negotiation body. In the first instance, it will be the business of your EWC to ensure your agreement meets the requirements. So my advice is, at this stage, look at your agreement, look at your directive, look at the new directive, see where the difference is, see where you need to change, and that is what you're going to need to put to management. That will be the business of an EWC itself. If that doesn't work, then you flip back to for the special negotiating body. But the main takeaway is that this is not an optional process. You should see what we're discussing today as the minimum requirements below which an EWC should not fall. Okay, very good. If the employer has previously refused to negotiate a new agreement, so there is no agreement currently in place, is the employer now obliged to negotiate a new agreement in line with the new directive? Excellent question. And again, something that we could discuss longer. Speaking frankly about it, this is a tactical discussion, okay? And I know the person who asked it is a tactical person. The subsidiary requirements are your protection, they're your basis, and that is below which you can't fall. Quite frankly, speaking as a tactic and openly, some management might say, better to see if we can negotiate an agreement than have greatly improved subsidiary requirements, okay? So it may be an incentive for management to make an agreement. It may be an incentive for management to make an agreement. The intention of the new directive is that you make agreements in order, as they say, to avoid disputes, okay? But does it force them to make an agreement? No, it's likely to be the same process as the questioner knows. After 4 years, you go and you look at it and you go from there. But either way, I suppose to the questioner, you're in a slightly win-win. If you're on subsidiary requirements, you're going to get new and better subsidiary requirements. Okay, that's going to take a few years before it finally happens. Okay, but you're going to get new subsidiary requirements, and it may be an incentive for your management to discuss and negotiate an agreement with you. Thank you very much. I'm going to go a little bit faster. Currently, we have one annual meeting with one SC meeting 1 month before operation and another SC meeting about 6 months after the annual meeting. Considering the fact that there should be now 2 annual meetings, how many SC meetings will we have? 2 or 4? Brilliant question. Absolutely brilliant question. And can I just be quick and brief on it? I suppose the way to look at it is, if you currently have 2 annual meetings, okay, you could look at having 4 annual meetings, okay, maybe more. There are some EWCs who have more. But I think it's very important that you look at the new directive as increasing and improving your rights. Now, in terms of select committee meetings and in terms of numbers per year, that's a matter still to be negotiated, okay? So it does not give you, there's no automatic number listed, okay? So you will still have to strive to increase your numbers of select committees. And important to look as well, and I should have mentioned it earlier, but seeing as the question was asked, important for you to remember that the new directive includes new topics for information and consultation at your annual meeting. So, for example, to give 2 examples, the just transition and the digital transition. So ensure that you use your second meeting to get your full information and consultation rights. And again, you can work with Syndex as experts, or you can work with your trade union coordinator, or both, in order to ensure that you get a good meeting. I hope that answers the question as accurately as it can. Great question coming in here. Hello to the questioner who I know. Do you honestly think, do you or anyone honestly think that the Irish government will transpose this directive with wording that will incorporate sanctions and penalties on companies that are deemed dissuasive? Well. And again, I only have, I think, about 15 minutes left. So, and again, apologies. I know I talk too much. So I'm preempting the reprimand from colleagues on this. Can I answer this question as honestly as I can? So the questioner mentioned Ireland, right? There are about 1,000 EWCs, and Ireland is the country with the fourth, and this is from memory, we have about the fourth most amount of EWCs registered under Irish law. The majority of companies registered under Irish law are not Irish headquartered companies. So US companies, companies from outside the European Union, etc. So the question of Irish law is a question not just for Ireland, it's a question for EU reps, employee reps right across the European Union. The direct question was: do you honestly do I honestly believe that the sanctions will be effective and disproportionate, etc.? I suppose, as my good colleague Stefan says, that's somewhat beyond my pay grade. In that, I suppose that is the business really of EWCs, of employee reps, to ensure that the transposition of the EU directive into national law, not just Irish law, but that it is accurate and that it is in line with the directive. It would be an absolute shame if the directive was not to be adequately transposed in every EU country. Okay, so I hope I haven't dodged the question. You didn't say, it's hard to say whether I believe or not. I'll tell you what I believe. I'll say to the questioner, I believe that the transposition should be accurate. And for today's purposes, today, to quote a colleague, the actual outcome will be beyond my pay grade, but it should be in line with the directive. So again, as I said earlier, a lot of this is going to depend on what's put into national legislation. For example, confidentiality, what is legitimate interest, what is effective, what is disproportionate. That will have to go into national legislation in all the countries. And no doubt the questioner will take a great interest in it. Okay, good. The next question. The new national law on the newly legal sector will apply in 2028, after 2 years for transposition and an additional 1 year grace period. Right. Excellent question. Okay. So if you look back on the slide, and it is important, I suppose many colleagues are listening to meetings and suggestions and are saying, when is this going to happen? Because time is running out, and everything in EWCs is slow, and everything seems to to be tomorrow. In this case, it's not so much tomorrow as it's a number of years. So if you look at it, this November should be, and I say should, the directive should pass through the European Parliament this November. Then the countries have 2 years, okay, to transpose the directive. And then there's another year period afterwards, by which I suppose you could call it a period of adoption, where companies, so that's a 3-year period. But if I can say to you, don't wait for 3 years. When it passes in November, or even now, start to look with your trade union coordinator, or you can ask us or any expert in the field, how to move your agreement from what it is currently to what it should be according to the new directive. But I know it's a little bit slow, and I know that can be frustrating for colleagues. Okay, excellent. Central management often turns to Ireland because of it's favourable for the employer environment and difficult for EWCs to go to court. Will it be improved? So it's an excellent question. The directive gives companies how to describe it. If you're headquartered in France or you're headquartered in Ireland and you're a company with an EWC, it's straightforward. Your EWC is registered in France or Ireland. Okay. If you are from outside the European Union, once you have an agent, you can then, select a country. Now, once the agent is in place in the country, you can do that. So, for example, if the company is from the US, or if it's from Japan, just to use 2 countries, not to pick on the US, but it is the one where there is the most amount of EWCs registering in Ireland. So look at it like this. Traditionally, they went and registered in the United Kingdom. That was where there was more of them based. But since Brexit, there has been an increase. So I think off the top of my head, there's been an increase of about, since Brexit, from about 16 to about 44. Now, the important thing to remember is some of them are actually EWCs that are registered in both the UK and Ireland. So not to get too hung up on numbers. So in the UK, and again, we're limited on time, but in the UK, under the CAC, there's been quite a bit of development in terms of what you might call case law, in terms of what you might call legal cases, taking cases where there has been the infringement of rights, and there's been a fair degree of success in that. The Irish law remains undeveloped. It remains untested. There's been one case taken under Irish law, and that's the Verizon case. My understanding of that case is that it's still ongoing. There was an adjudication in the WRC, which went to the Labour Court, and which is now with the High Court. So the question is, I suppose, how all of this is transposed from EU level into the Irish legislation. The intention of the Commission, the intention of the directive is that it is transposed adequately. And the Irish government will be obliged to tell the EU Commission how it is implementing it. They must, for example, say very clearly, this is how you access justice, my words, okay? And also, you will get, under the directive, access to legal experts. There is mention of budgets, etc. Perhaps that's for another day, but you will get increased access to legal experts. So I suppose the questioner, in terms of Ireland and Irish law, it is to say that the directive will be transposed into Irish law. And to quote my colleague, that's slightly above my pay grade in terms of what can happen. But the intention of the directive and of the Commission is that it is adequately put in place. Okay, good. How am I doing for time? Is there many other questions? Just one more question. Does the new directive bring any clarity regarding UK reps' involvement in the UK EWC agreements? Brilliant question, and I really wish perhaps we'll have a follow-up meeting to this one if you could bear with me for another time, because these are really good questions and time is not my friend. So again, to speak on the policy of many of the trade union federations, or perhaps all the trade union federations, is that the UK reps should be included in European Works Councils when they are formed, i.e. during the special negotiating process, and that they should stay as members of EWCs. You will know that in some cases that hasn't been the case. In other cases, it has happened. And in other cases, of course, EWCs have remained under UK law. Quite frankly, there's no great change in between this directive and the last one in terms of UK representatives and in terms of the question you asked. All I can say is, again, slightly beyond my pay grade, but requires vigilance, requires coordination with your trade union coordinator, your trade union federation, to ensure that EWCs not only include the EEA countries, European Economic Area countries, but of course, colleagues and workers in the United Kingdom. Excellent. A very good question. So I'm very conscious of time, and perhaps I need to wrap up. I just want to thank everybody really, really sincerely for attending the meeting today. Please, if there's any questions, follow up with us. We will send you, if that's all right, a follow-up email just to see, do you want to have any further questions, etc. Conscious that we perhaps didn't get as much discussion today as we could have done, because there's a lot more questions and a lot more points coming in that I can see. I just want to very sincerely thank my colleagues in the Paris Syndex office for all your help and assistance. My colleagues in Dublin, Shreya, Anne, Ridiger, Robert and Stefan, thank you very much for your assistance. Any mistakes, technical or otherwise, are my own, but thank you very, very much for your participation, for listening, and for your questions. Okay, will we leave it there? Thank you very much.